Thank you, Mr. Nightingale. I've had a chance to review that letter. Go ahead with any elocution on behalf of your client.
Thank you, Your Honor. So on behalf of Mr. Willnow here, he comes before the court, 53 years of age. He does have 5 prior felonies, 13 misdemeanors. He has a binding sentence agreement here for a county cap as to both these cases. Obviously, the PSI recommendation does not comport with that agreement. We think that the court should follow the agreement of the parties rather than the recommendation contained within the PSI for a few different reasons. First is, obviously that Mr. Willnow has accepted responsibility for these cases, and that should be considered a mitigator in some respects. Further, Judge, Mr. Willnow has got some pretty significant health issues. I think these are outlined fairly well in the PSI, but in addition, in Mr. Willnow's sister's letter that the court has now reviewed, he suffers with some pretty intense diabetes and has done for a long period. It's my understanding that within the jail, he's having a real problem getting his sugar under control. It's not exactly the best environment for somebody who's dealing with those kinds of major health issues, not just for him, but also for the jailers. Frankly, that's potentially a lot of liability and a lot of maintenance. That kind of diagnosis requires constant surveillance, and they have better things to be doing, I think, at the end of the day, although they are constitutionally obligated to make sure that Mr. Willnow is alive and well inside the jail. And so these two things are obviously in conflict. We're asking the court to abide by the agreement and to sentence him to a limited county sanction. He has done some prison time. It's been a long time. His history, although fairly large, is also quite old. I mean, his first conviction, at least in the PSI, is from 1989. That was for a misdemeanor or larceny, what he pled to. He's done treatment at least once before as part of a parole sentence that he received in the late 2017 matter, I think. He did Harbor Hall as a part of that sentence. As a part of this case, while he was out on bond, he did go to Bear River for a little while. He was unfortunately not successful at Bear River because of his health issues. I don't think it was a lack of commitment on his part. He just had such a hard time dealing with his diabetes while he was there that it made it pretty difficult for him to even attend classes. And so, although he tried to get the most out of it as he could, he was just very sick while he was there and ended up being discharged for those reasons. He did also apply for recovery court here, was told that he's not a high enough need / not a high enough risk to reoffend. And so that, I think, that cuts both ways, right? Is that he doesn't get the program that he may so desperately need, and also then the court then should consider him a low risk to reoffend, right? I mean, if he's not in that category, he's in the other probably. And so I would say, based on his age, the fact that he got busted for this basically twice. One of these was essentially just a residue case of, he's got the first case and then he's found in a house with some residue in front of him. The court should consider these to be not the most serious, charge as far as the continuum of the charges are concerned, right? I mean, I think, as the court noted earlier, it's this could have been a large quantity of methamphetamine, and it still would have been the same charge, the same penalty. And so it wasn't, right? This is sort of a personal use thing. Although he's got the dealing ahead of it, it's, I think, Mr. Willnow's contention that he was sort of engaging in this type of behavior as a way to both account for his personal use and to try to take care of his fiance that was dying at the time. He does have some periods of extended sobriety as far as, heavy drugs and narcotics are concerned. It does seem in the PSI that Mr. Willnow has indicated that he doesn't really indicate or intend to cease his use of marijuana or alcohol. You know, he is 53 years old. He's been doing that kind of stuff for a long time. I don't think the alcohol use is helpful for his diabetes, that's for sure. And I think that he's starting to recognize that. Certainly, I don't think Mr. Willnow would have had any bond issues had he been able to just quit drinking. That would have made a much easier argument for us going forward right now, and probably could have let us resolve this case a little quicker. But nonetheless, he did have some issues. What I think is most notable for him is that he has recognized those issues since our last court hearing when we tendered our plea. The court did continue his bond after he tendered that guilty plea as to both cases. And then Mr. Willnow out in the hallway basically demanded that the court revoke his bond. He just was not confident that he could stay on the straight and narrow here while his sentencing hearing was pending. And so I certainly commend him for that accountability and for that sort of self-knowledge. You know, not a lot of my clients have that kind of insight to know themselves enough to say, I can't do this and I need to not be out right now while I have this really good deal the prosecutors give me. And so we're asking the court recognize that as well. I think the court has done that in some respects already, but just want to remind the court that that did occur, that Mr. Willnow has taken great accountability here. He's willing to do anything the court orders him to do, but mostly he wants to be out to support his family. As the letter that his sister wrote indicates, you know, he's got some family members out there that really need his assistance. You know, he could do some jobs out in the community, although he's on disability. And so I think more than anything, it's more important for his family members that he be out and that he be able to take care of his other family members that have these other significant health issues, not diabetes related. So, Judge, all that being said, you know, Mr. Willnow is ready and willing to do anything the court wants him to do, up to including completing treatment again. I think that if the court decided to put him on probation, he would, of course, cease his use of alcohol and marijuana as a part of that probation sentence, because he would have to. And so, but if the court does not want to put him on probation, if the court thinks that he's not a good candidate, we would just ask for a county sanction, no additional probation, limited fines and costs. And that's it. Thank you.
Thank you, Mr. Nightingale. Mr. Willnow, you don't have to say anything today, but you're allowed to. Is there anything you want to tell me or no?
No.
That's fine. Ms. Goodrich, any recommendations from the people?
Yes, Sharon, thank you. What led us here is the defendant had delivered LSD with the help of a co-defendant. When he was arrested on that, he was found with methamphetamine. To his credit, he was honest and cooperative with the officers. He admitted that it was his and he liked to mix it with his marijuana. The defendant is 53 years old. He has 5 felonies and 13 misdemeanors. He admits in his PSI he's had daily use of methamphetamine beginning in 2024. That he's not likely to abstain from alcohol and marijuana, no desire to. I would agree with Mr. Nightingale. He was honest and turned himself in. We were last in court knowing he wouldn't be able to abstain from alcohol. So probation doesn't make sense at this point. The plea agreement is to a county jail cap with $100 restitution. I would ask the court to order 10 months jail, which is still within the Michigan sentencing guidelines. Thank you.
All right, Mr. Willnow, if you please stand for the court sentence. Well, Mr. Willnow, you know, you're 53 years of age. You have 5 prior felonies, but I note your last felony was well over 15 years ago. Had some misdemeanors in that time frame. And, you know, you know yourself well enough that you knew that you weren't going to comply between the plea and the sentencing. In fact, you had some difficulties back in the jail because of how much you'd indulged and just stopped testing prior to. So I hope you're past that difficulty now. But I think, you know, that I think explains the recommendations of the Department of Corrections for a prison commitment, because I think there might be some frustration that I frankly share that, you know, you don't seem interested in change. That's a good reason not to put you on probation. And so I'm not going to do that. And, it's been over 20 years since you had a drunk driving. So, I mean, alcohol and marijuana are both legal and you're not on probation. You can use those as much as you want and kill yourself with your diabetes if you want. As long as you don't drive. But you're not here because of alcohol or marijuana. You're here because you were selling LSD. So you got to know, you start getting involved in that, you're going to be back in front of a judge. So if you want to get as drunk or stoned as you want and not go in front of a judge, you do you and do the legal stuff. But you start getting into selling drugs in our community. And with your history, delivery of LSD is not the class of that sentence is not as much as, like, if you'd been caught selling methamphetamine, you'd be guaranteed prison sentence. But even with the LSD, it's a guidelines that would allow for prison. So, when was the last time you did prison? How old were you when you did prison last time?
2017.
Okay. So like almost 10 years. Well, okay, 8 years ago. Okay. So you were in your 40s. Well,
Yeah.
Life, I'm sure if you've noticed, in your 50s is a little tougher than when it's in your 40s.
Yes.
And prison in your 50s is probably going to be tougher than prison in your 40s. So I don't know. I don't know what to tell you, Mr. Willnow, other than what you ought to do to avoid going to prison. I think on the balance, doesn't make any sense to place you on probation, but I do agree with your attorney and the prosecutor that with this plea agreement, that there's nothing about the facts in this case that really cry out for a prison commitment. So I'm gonna go ahead and stay within those bounds. So, Mr. Willnow, in file 7027, the possession case, I'm going to order that you actually in the pre-sentence report, I think the restitution is tagged in that case, but I think it's supposed to be in the 7028. So in 7027, I'm going to assess $68 in state cost, $130 crime victims assessment, and $350 in court costs, and order that you serve 10 months in the Sheboygan County Jail with credit for 51 days previously served. That's within the advisory guidelines and the plea agreement. In 7028, I'm going to order that you pay a $68 state cost, $130 crime victims assessment, and $100 in restitution. And that in that file, you serve 10 months in the Sheboygan County Jail with credit for 74 days previously served. And those sentences will run concurrent with each other. If you wanted to appeal, you may do so by filing an application to the Court of Appeals. If you wanted a lawyer, I would give you one, but you'd have to make that request within 6 months. So we're going to hand you a piece of paper explaining those appeal rights in both files and ask you to initial one copy for us and the other ones for you to fill out if you want to take an appeal. Do you have any questions for me, sir?
Is there any way I can do community service or anything while I'm in the jail?
Yeah, I gave some thought to that with the length of sentence. I a lot of times approve that, but I think given Mr. Willnow's, I guess, demonstrated lack of, I guess, hope for real change here, I'm not going to approve any programming. So you'll get your good time credits, but I'm not going to approve any additional credits. All right, so good luck, Mr. Boone.
Your Honor, confirming at this time, if I could just make a brief record as to the plea offers and counter offers.
Sure, go ahead.
Did talk to Mr. Juliet this morning. His offer up until this point has been to count one, no agreements, dismiss the other counts. This morning made a counter offer that he did agree to, but Mr. Middleton did not. So the counter was for a no contest to the UDAA as a habitual third. Those guidelines would be, I think, 12 to 36 months. Mr. Middleton is aware of that offer, has rejected it at this time, and wishes to confirm for trial.
Okay, and Mr. Middleton, by placing that on the record, I think there's just sometimes a need just to make sure that there's no later claim that your lawyer was ineffective for failing to communicate that to you. Mr. Nightingale, by putting that on the record and me asking you about it, is in no way, shape, or form trying to coerce or persuade you to enter a plea at all. You understand that?
Yes, sir.
Okay, I just want to make sure you feel like you've had sufficient time to discuss your options with Mr. Nightingale.
Yes, sir.
Okay, and he's given you advice about that, and you believe that's in your interests, or it's your desire to go forward with your right to a trial.
Yes, sir.
Okay, no problem at all. I did receive a stipulated order regarding trial clothing that talks about no restraints. And I'll sign that just so that it's clear, but that it is this court's practice that we wouldn't have Mr. Middleton in any restraints. If he arranges or you arrange for him to have whatever clothing he wants, he'll be able to wear that. And then on the trial day, the bailiffs will arrange, for his entry into the courtroom. The court officers have been doing a great job with that. I've talked to juries after the trials, and I've asked them whether they had any awareness that the defendant was in custody, and so far they never have. So we've done really good with that. I did have a question though. I haven't prepared the jury instruction books yet, but as I'm looking at the requested jury instructions, it looks like the people are now asking for a lesser included offense instruction for entry without breaking with intent. That's the 5-year. Is that correct, Mr. Juliet?
Yes, it is.
And now I've received a defense proposed instructions that are asking for a lesser offense of entry without permission. And I assume that's the 90-day misdemeanor?
Correct.
Okay. So I guess I wanted to hear from you both about whether both of those are appropriate as lesser included offense instructions, and I can fashion a verdict form that includes those options. Mr. Juliet?
I mean, I think they're both appropriate at this point. I mean, a jury could find that he didn't break but entered the structure in question, and the jury could find that he did break in without intent. So I think they're both necessarily lesser included. They're both appropriate.
Mr. Nightingale?
I agree.
Okay, I just wanted to clear that up so that we're not on the day of trial where I've got all these things printed out and have to reprint them. So I'll prepare things with both the